Canon law, the Eastern Orthodox and Oriental Orthodox churches, and the individual national churches within the Anglican Communion. The way that such church law is legislated, interpreted and at times adjudicate varies widely among these four bodies of churches. In all three traditions, a canon was originally a rule adopted by a church council. These canons formed the foundation of canon law. Greek canon, Ancient Greek, canon, Arabic kanun, Hebrew kan, straight, a rule, code, standard, or measure. The root meaning in all these languages is reed. See also the Romance language ancestors of the English word cane. The apostolic canons or ecclesiastical canons of the same holy apostles is a collection of ancient ecclesiastical decrees concerning the government and discipline of the early Christian church, incorporated with the apostolic constitutions which are part of the ante-Nicene Fathers. In the 4th century, the First Council of Nicaea calls canons the disciplinary measures of the church. The term canon means in Greek, a rule. There is a very early distinction between the rules enacted by the church and the legislative measures taken by the state called leges, Latin for laws, jus novum, jus novissimum, jus codicis, other sacraments, sacramentals, sacred places, sacred times, supra-diocesan, eparchal structures, particular churches, juridic persons, philosophy, theology, and fundamental theory of Catholic canon law, clerics, office, juridic and physical persons, associations of the faithful, pars dynamica, canonization, election of the Roman Pontiff, academic degrees, journals and professional societies, faculties of canon law, canonists, institute of consecrated life, society of apostolic life in the Catholic Church. Canon law is the system of laws and legal principles made and enforced by the Church's hierarchical authorities to regulate its external organization and government and to order and direct the activities of Catholics toward the mission of the Church. In the Latin Church, positive ecclesiastical laws, based directly or indirectly upon immutable divine law or natural law, derive formal authority in the case of universal laws from the supreme legislator, who possesses the totality of legislative, executive, and judicial power in his person, while particular laws derive formal authority from a legislator inferior to the supreme legislator. The actual subject material of the canons is not just doctrinal or moral in nature, but all-encompassing of the human condition, and therefore extending beyond what is taken as revealed truth. The Catholic Church also includes the main 5 rites of churches which are in full union with the Holy See and the Latin Church. All of these church groups are in full communion with the Supreme Pontiff and are subject to the Code of Canons of the Eastern Churches. The Catholic Church has what is claimed to be the oldest continuously functioning internal legal system in Western Europe, much later than Roman law but predating the evolution of modern European civil law traditions. What some might describe as canons, adopted by the apostles at the Council of Jerusalem in the 1st century, would later be developed into a highly complex legal system encapsulating not just norms of the New Testament, but some elements of the Hebrew, Roman, Visigothic, Saxon, and Celtic legal traditions. The history of Latin canon law can be divided into 4 periods: the jus antiquum, the jus novum, the jus novissimum, and the Code of Canon Law. In relation to the code, history can be divided into the jus vetus and the jus novum. The canon law of the Eastern Catholic Churches, which had developed some different disciplines and practices, underwent its own process of codification, resulting in the Code of Canons of the Eastern Churches promulgated in 1990 by Pope John Paul II. Roman canon law is a fully developed legal system, with all the necessary elements: courts, lawyers, judges, a fully articulated legal code, principles of legal interpretation, and coercive penalties, though it lacks civilly binding force in most secular jurisdictions. One example where it did not previously apply was in the English legal system, as well as systems, such as the US, that derived from it. Here criminals could apply for the benefit of clergy, being in holy orders, or fraudulently claiming to be, meant that criminals could opt to be tried by ecclesiastical rather than secular courts. The ecclesiastical courts were generally more lenient. Under the Tudors, the scope of clerical benefit was steadily reduced by Henry VII, Henry VIII, and Elizabeth I. The Vatican disputed secular authority over priests' criminal offences, and this in turn contributed to the English Reformation, The benefit of clergy was systematically removed from English legal systems over the next 200 years. Although it still occurred in South Carolina in 1827. In English law, the use of this mechanism, which by that point was a